Breaking news out of Michigan. We have a verdict in the fugitive wife murder trial. The jury has deliberated for 1 hour, 51 minutes. Everybody's back in that courtroom. Let's go in.
Number 7, it's my understanding you are the foreperson. Would you please stand and read the verdict form? No, they were released.
Oh, they were released.
It's okay. It's been a long week. Juror number 7, would you please stand up and read the verdict form?
Okay. So on count 1, we the jury find the defendant guilty of second-degree murder. On count 2, we the jury find the defendant guilty of dead bodies, disinterment, and mutilation.
Thank you. Please be seated. Juror number 1, was that your verdict?
Yes.
Juror number 2, was that your verdict?
Yes, it was.
Juror number 4, was that your verdict?
Yes.
Juror number 5, was that your verdict?
Yes.
Juror number 7, was that your verdict?
Yes.
Juror number 8, was that your verdict?
Yes.
Juror number 9?
Yes.
Juror number 10, was that your verdict?
Yes, ma'am.
Juror number 11?
Yes, ma'am.
Juror number 12?
Yes.
Juror number 13, was that your verdict?
I was 14, but yes.
Oh, yes, okay. Ladies and gentlemen, I can't thank you enough on behalf of Eaton County, on behalf of the prosecutor and the defense, and on behalf of myself. This was a long trial. Yeah, there were many exhibits, many witnesses, and it was very difficult. And I greatly appreciate the service that you have performed. I would ask that you just wait a few minutes back in the jury room, and I'll be back to talk to you.
All rise for the jury.
Please be seated.
I have a sentencing date of May 23rd at 1:30. Would you all please check your calendars and confirm that that date works? May 23rd at 1:30.
That works for the defense, Your Honor. Your Honor, the only reservation I would have at this moment is I'll accept the date, but I will most likely have an individual coming in from Texas, Sicily, who would want to speak and would have the right as the daughter of the victim. I'd obviously like to confirm with her. I will do so quickly, and if the date doesn't work, would let you and the defense know.
I assume that we would have a testimony or statements, which is why I didn't set it on a normal criminal time, and I set it for 1:30 to allow as much time as possible. If she can't be here on May 23rd at 1:30, like you said, please let me know as soon as possible so I can confirm a date with the defense also, okay? All right, Ms. McCallum, you have been found guilty by a jury on counts 1 and 2. I enter a guilty verdict on counts 1 and 2 as charged. Sentencing will be, as of right now, May 23rd at 1:30. Mr. Lloyd, is there anything else you need to place on the record this afternoon?
Not on the record, Your Honor. Thank you.
Mr. Havis, anything else for the record?
No, Your Honor. Thank you.
Thank you all very much. That's all for the record on this file.
All rise.
Guilty on both counts. Probably not a surprise to all of us watching this trial together. Again, second-degree murder was the first count. The second was the dead body disinterment, mutilation of dead bodies. So let's bring in now Deputy Public Defender Philip Dubé, Criminal Defense Attorney Josh Schiffer, two of our experts I'm grateful to have on today, because I don't think the surprise is that it was guilty on both counts, but I do think it's surprising it was 1 hour and 51 minutes that they deliberated. Not very long. Tell me what you think, Philip.
Oh, no, I think the jury got it right. But I will say this. I actually respectfully disagree with the jury on count 2. I looked at the statute there in Michigan regarding disinterment and mutilation of a body. And the statutory scheme for those 2 crimes is codified in the burial law section of their code, meaning it governs what happens when somebody actually goes inside of a grave that was like a lawful plot created in fee simple, that trite expression that we use in property law. And really what you had here was basically a tin box in a blueberry patch. And to try to conflate the definition of burial law with finding a tin box in a blueberry box or in a blueberry patch just to stick her with another 10 years, I think is tortured pretzel logic. I don't know if Josh would agree, but we'll see what the court does with that. As to the murder, boy, did she get a break. And Ashley and Josh, you remember she was extradited from the old country of Italy. She fought extradition, and Italy took on the United States because they do not believe in a life without parole type sentence, even on a homicide. So they refused to extradite her on a first-degree murder, and luckily for Bev, Michigan agreed to amend to a second degree. And you know what that carries? The judge could give her less than life. Obviously, it could carry life, but the judge could give her a determinate term of less than life. She's 63. You never know. She could get 20 years and be out and have a little bit of life ahead of her, not to mention that she was on the lam all these years at liberty. So all in all, it was a good result for her.
And well, all right, let's talk about the disinterment, because I did the same thing. I was looking it up because I thought, well, that's kind of surprising to me. Mutilation of a dead body, I do get that, so I understand that piece of it. But putting that aside, Josh, a couple of things I can't help but point out. First of all, she did not change her expression as the jury read the verdict of guilty on both charges. The judge then said, I am going to find you based on the jury and their deliberation. I'm going to find you guilty of both of those charges. But look, it's the same expression really she's had the entire time of the trial. I don't think that bodes well for her sentencing, Josh.
No, and I think that, as Philip brings up, there's some interesting kind of side issues here, but we all knew, having watched the case, that a conviction was very likely. And Bev, I think Bev's known this result was baked in, and I don't think that she expects to really spend a lot of time out fishing and hunting and wandering the woods or the Piedmont of northern Italy chasing truffles. I think she's going to spend the rest of her days locked up, because not only does the judge have this discretion under Michigan's second-degree murder statute, but there is that additional set of sentences on top of, can be served consecutively to that first sentence for the body issues. But I agree, that body issue is where the appeals can come. And lots of times people are just concentrated on the trial. Oh, what's going to happen, guilt or innocence? That's only part of the fight. In a lot of criminal defense issues, it's actually the appeal where you're going to get the most movement. Because if the state has overreached with some of these issues, that's where a more superior court will bring it back. So we'll have to see how much time she gets, even though I imagine her next release is going to be for some sort of medical compassion or in a box. I don't see her going very far. That pre-sentence report's going to be brutal.
And a different set of facts. However, Scott Peterson, to your point, he's the reason we're back in court today because of appeals. So you're right, Josh. You have to be cautious, because going down the road, it can make a really big difference in what happens with the defendant. Now convicted, but I have to ask you both this, because in watching the trial, really I felt like it came down to Chris McMillan. He was the witness, everyone may recall, who's now in jail with the glasses that he needed in order to see, but they look like sunglasses, testifying. He's the one that said it was her. She then, when she testified as the defendant, her choice, she chose to testify. When she testified, she said, no, I did hit him with a tool. It did, you know, have a spot from that, but it was Chris McMillan and my daughter responsible for the rest. Clearly, I think that they decided she wasn't credible, because theoretically that could have, Philip, given them a little reasonable doubt.
I don't think so. I think if anything, it solidifies the guilty. She basically admitted to clobbering him in the head, and she didn't know what it was. It certainly wasn't a magic wand or a conductor's baton, you know? She had a hard tool-like instrument in her hand and whacked him. So I don't see how you can do it accidentally. And if you did, you get on the horn and you call 911. You try to render aid, you do something. You don't then just put a bag over his head, smother him, set him on fire, and put him in a tin box in a blueberry patch. Otherwise, you look like an aider and abettor to the murder. So had she not have said that about accidentally hitting him in the head and really not knowing what it was in her hand, I think she had a shot, frankly. But she admitted complicity by saying she struck him in the head. I thought it was done at that point. I thought, you know, the jury was going to have no choice.
That's right. She admitted complicity. That's the part, Josh, that she admitted. But she admitted one other thing, or rather, this came out by her choosing to testify. She had 5 husbands, some suspicious things about those 5, but 2 of them were brought out during her testimony. One of them missing. That's right, missing. I think that's something that jury might have held on to also, Josh.
Absolutely. They've got that other, you know, associative facts that allow you to really kind of paint a dim picture of someone. But what Philip said was dead on. If he was going to actually, or if she was going to actually admit, which she did, participation in this eventually brutal killing. It was, you know, could be even called an assassination, the way that it was planned and set up. She needed to really cleave herself away from the 2 other allegedly primary actors, try to get away from being a major stakeholder. And unfortunately, by trying to mitigate her own involvement and walk away and waffle a little bit, it made her look more culpable. And that was, I think, the real sinker, like Philip's saying.
All right, I'm going to throw my entire crew because there's great sound they pulled. And at first I thought I wanted to listen together to one piece, but I actually want to see if we can listen to the defense closing, because they did make a point that, again, perhaps just looking at this, could it have been enough to sway a juror? Clearly it wasn't, because they found her in 1 hour and 51 minutes, if you're just joining us, guilty of both counts. That includes the second-degree murder. But defense closings points out about a motivation that she may or may not have. Let's see if we can listen to that together.
What is the possible reasons that Beverly could have had to kill Robert? Well, the prosecution wants to say that she wanted to run off to Jamaica. She could have done that countless times. During the course of their relationship from 1988 to 2002, Robert had been incarcerated, we heard through testimony, numerous times. She could have left him at any point in time as he was incarcerated. Instead, she chose to move the family wherever he was incarcerated so the kids could be closer to him. So it'd be easier for them to maintain visitations during holidays, birthdays, significant events. That's how she actually handled herself in this relationship. She could have easily just waited for the next time he went to jail and then made that decision. There's no motivation that my client had to actually kill Robert at all. There's motivation for Kristen and Dean to have done so.
All right, Josh, what about that? This isn't the case where they laid out a whole lot of motive that she had for killing him.
You know, there's just so much that we can get into with, you know, what they were trying to do to walk her away from it. But at the same time, the overwhelming evidence from the state never got confronted really well. And I'm a big believer you've got to give that jury a hook to hang their hat on. You've got to, when there's this kind of overwhelming evidence, really almost tell them, this is how she is innocent, this is why she is innocent, or this is why the process of prosecuting her has been so unfair. And they didn't link that together in that closing argument. And at that point, I feel inertia in this case was really strong. We had the co-defendants who have already been convicted, already serving that time. I just think that it's almost impossible to redirect a jury when they're in that inertia position already.
All right, Philip, I'd like you to put your deputy public defender hat on and tell me, how do you think you would be feeling after this verdict, given the facts of the case and the case put on by the prosecution?
Well, I would feel that justice is served. I must say, as a defense attorney, obviously you want to do your best to advocate for the client, but make no mistake about it, we know the strength of a case. And sometimes when you are in the thick of it, in the heat of the battle, you go through what I call trial denial, meaning you latch onto these little kernels of hope, these little kernels of doubt that you truly believe are going to set your client free, but they pale in comparison to the tremendous quantum of evidence that the prosecution is putting forth. One thing I would have hammered more in this particular case as defense counsel is the presence of that third-party donor DNA at the scene. Remember, you have unknown DNA contributors. They don't know who they are. But what we do know is that they were not Beverly's DNA. So had she not have testified, I would never have put her on and said, well, you know, I swung that thing too. I would have kept her off. I think that third-party DNA could have been her only hope. But putting her on and going in and out of that pretentious Italian accent, I thought really sunk her ship. Frankly, when she went down like, yeah.
And I didn't mean to interrupt you, Philip, but so many people commented on that, the change of her accent throughout her testimony, and viewers watching, and it was bothersome. I think that's what a lot of people really picked up on, so I'm glad you raised that. Let's do this, Josh, because obviously they agreed with the prosecution. The jury did guilty on both counts. Let's listen to a little bit of the state closing, and then, Josh, talk about what they had to say.
Then all of a sudden it became, I'm scared of Chris. Chris, who has basically moved in with them. On that day, all of a sudden she becomes scared. On cross-examination, it's then she changes and goes, well, Deneen came upstairs and saying, Mommy, help me, I've killed Robert. But even then, when asked, what did you do? Nothing. I went and laid down. This is your love. Your husband, somebody's just sold you, your husband's dead. You don't check on him. You don't try to figure out what happened. You don't do anything.
Josh, for me, that really hit the mark, because I think it's unreasonable to think that a person wouldn't do something. And she did nothing. Your thoughts?
It's those unanswerable questions where, all right, if you encounter this, you had to do something. You can't have, you've got to compare and contrast, where if you can effectively compare and contrast the person you're talking about and make it show how, even in their own words, they didn't do the basic thing that any human would do, you're directly attacking the consistency of the testimony. And the lack of consistency in this case doomed Beverly, because she didn't have a standard story that stayed together. And as soon as you're illustrating that in front of the jury as the state, you're getting that beyond a reasonable doubt, because you don't trust the defendant's words. The lack of consistency will get you every single time.
Yeah, absolutely, that lack of consistency. And then don't forget, the state called as a rebuttal witness the daughter, who was 9 at the time, who said some things like, no, she did use drugs. I knew she was in the bathroom doing crack, etc. So some of those things, I think the jury could decide that mother wasn't credible. Convicted on both counts.